Good morning, everyone. I'm Joanne Koontz. I'm here with my partner, Jackie Durham. Today's Tuesday, April 20th, and we are going to be bringing to you today another real estate topic. We're going to be talking about lease options and lease purchases. They're different. I hear people routinely use those terms synonymously as though it is a lease option / lease purchase. That's not actually the case, and we'll dive into a little bit of what that looks like. And we're going to talk about some pros and cons, some things to be careful of if you are maybe a realtor and you're putting one of these deals together, or if you're a buyer or seller or tenant or landlord. If you're considering putting one of these transactions together, this is good information. We do see this with some frequency, particularly in existing landlord-tenant relationships where people say, you know what, I'm going to buy, but I'm not really ready yet. So maybe this time we'll do a lease. And we'll either do an option or a purchase. Like I said, though, typically, I don't know about you, Jack, but when the people call me, they're saying like, I need a lease option or lease purchase, or, or a lease option to purchase, or something like that, where they're kind of mushing them together. And that seems to not always be clear that there's a distinction. So anytime we're getting involved in these, we got to be careful. And of course, we, as always, have our typical warning that this is not something for Google. Like, please do not pull the agreement off of Google and then ask me to read it.
Right. And I think another reason why we wanted to kind of share this content with you guys today is also because I've had several clients who have been having some trouble in the court system when they go to evict certain tenants who have defaulted under their leases. And it's because they're not structuring these transactions properly. And it's really important to do it right at the outset. So unfortunately, some of my clients have come to me after the fact, and I have to kind of clean up their forms and make sure that what they're doing is not going to put them in a position where they're having to foreclose an equitable interest versus just evicting a tenant, which is a much faster and easier process.
Oh, yeah. This all sounds good until it doesn't go good. And then what happened?
Yeah. Right. And like you mentioned, Joanne, the lease option, lease purchase, those terms are kind of used interchangeably because they are similar in concept, but there's some really important distinctions. The lease option is really a residential lease agreement and a separate option agreement, which grants to that tenant the right to put an offer in on the property. And it basically holds that option exclusive to that tenant for a particular period of time. Whereas a lease purchase is an actual residential lease that's signed, and at the same time, the tenant / buyer is signing a purchase agreement, agreeing to purchase the property on some future date. One thing that I think we can start with, and I think we should probably maybe go through the lease option transaction first, and then we'll shift over to the lease purchase. I think one of the main things that I would impress upon our viewers today is that you really need to make sure that the residential lease agreement and the option agreement are two completely separate contracts. One of the main things that gets my clients into trouble is when they kind of merge these two documents together, and you have option terms kind of intermingled with the lease terms. This is hands down one of the major ways that people find themselves in trouble, because it might be confusing to the buyer / tenant that they don't have some kind of equitable interest in the property when they're when these terms are sort of intermingled. So it's really important to keep those contracts separate. I wouldn't even include the option agreement as an exhibit to the lease. Even that is not good enough. They need to be complete standalone agreements. Another really important item I would mention is the lease payments should not reduce the ultimate purchase price. They should not apply as a credit. That is literally an installment agreement, and the judge is going to view it that way. And also the option fee. This is the fee that the tenant / buyer is going to pay to reserve that option for that particular period of time. That option fee should also not reduce the purchase price or apply as any kind of credit. That is separate consideration for the seller holding that property off the market in favor of that buyer for that particular period of time. That is a complete separate piece of consideration. I see all the time when parties are trying to work a deal,
Mhm.
they say, oh yeah, you know, you pay this option fee, but it'll reduce the purchase price at closing. You can do that to sweeten the deal for the buyer, but keep in mind that that's going to be ultimately something that the judge will use against you if you go and try to evict that tenant later because they default under the lease agreement. That will establish an equitable interest in the property.
Yeah, and then you're stuck with, you know, a completely different remedy. You know, you're now looking at closure rather than. Now, can you talk a little bit about can I back you up a little bit on that rent credit issue? Is it, obviously there's good, better, and best when we do any of these things. So best is to give no credit. Is there any amount that you've seen that you feel like, well, if it's a little bit is okay? Because, you know, a lot of times people are trying to like give the buyer an incentive not to walk away. In this market, it's not hard because if the buyer walks away, they're going to pay more for something down the street. So this particular issue is not at the forefront of why people are falling out of these agreements right now, because we're in an escalating price environment where it's not really attractive for the buyer to walk away. So it's, you know, for today's listeners, it's maybe not a big deal, but this market we know is cyclical and it will not always be like it is today. So when it's back to that, like we really need to hook the buyer in, is there like 10% or any kind of portion of that rent that you feel like is okay as a rent credit, or are you sticking to zero?
Well, I would, you know what, 5 years ago, I would have said you can maybe flirt with that line a little bit, but recent court decisions that I've seen, no. Like I've had clients come to me with what are not, they're agreements that aren't written on the back of a napkin. They're decent agreements.
Yeah.
And they've even separated stuff, and they even have a non-refundable option fee, and they seem to be doing everything by the book, and the judge is still requiring judicial foreclosure. So I would say, I would typically recommend you charging the fair market rental, but if you're trying to give the buyer, if you're trying to entice the buyer with something, I would maybe reduce the rental before I would allow the rental to serve as a credit against the purchase price. That's what I would recommend.
Okay.
And you also, as a seller, you need to be careful in the lease agreement. There are traditional expenses that a landlord typically assumes under a residential lease, such as taxes, hazard insurance, HOA dues,
HOA fees. Everybody wants
repairs.
to take HOA fees on the tenant.
Yeah, no, you should not be prorating these in advance of closing. You should not be shifting or allocating these expenses to the buyer or the tenant, because again, these are not things that they would typically assume under a traditional residential lease. So if you start treating it like something different, the judge is going to look at it as something different. So you need to make sure under that lease agreement, landlord, seller, you are assuming all of those normal obligations that you would if this was a standalone lease, because that's how you have to really treat it. There's also something I wanted to mention. In addition to making sure you're doing all these things properly, I think that specifically including something that is acknowledged in the lease, especially if the option to purchase is referenced in the lease, you need to include something where the tenant is acknowledging the fact that the rental payments are not a down payment, the option fee is not a down payment. And I even have I wanted to share a little clause so that everybody can see this. This is
Jackie's Friday Night Fun. Underlining in bold.
This is what I think, and that's the other thing. Our good friend Mike France, who's a really great litigator locally, has imparted upon me the importance of making things very conspicuous. So if you are concerned about a party to a contract acknowledging something and not being able to later say that they didn't see it or they didn't understand, you just bold and underline and put that stuff in caps. So that's what I've done here. This is going to apply to, this is just an example of a clause you can use. Of course, you need your attorney to review and make sure it's, applies to your particular contract and circumstances. But this is something that I've included in some of my lease options. This would go in the actual residential lease. And it's basically the tenant acknowledging, I understand that the option fee and the monthly rent are not considered a down payment. They're not going to be credited against the purchase price. and it's not going to convey or vest in me any kind of equitable interest. So I think that that is a good thing to include as belts and suspenders. And, you know, it can't hurt. Especially if you're doing all the right things, if you expressly put it in there, the tenant's going to have a really hard time arguing otherwise later, and a judge is going to have a hard time ignoring that bolded and underlined clause. So.
I just have one question. When you were in law school, is that what all of your study notes looked like? Like everything was highlighted and bolded and underlined? Exactly. Like everything's important. Sometimes I would look back at my materials like I don't even know what to read first because I underlined and highlighted everything.
Different color highlighters. I mean, it was ridiculous.
PTSD
ridiculous.
For you.
Yeah, and I'm still offending in the same way. So, so that's a good example of what you need to be cognizant and mindful of when it comes to the lease agreement in the context of a lease option. Now, something else I would mention that parties make the mistake of doing is make sure in your lease agreement you are identifying the parties as landlord and tenant, or lessor and lessee, not as buyer and seller, and not as optionor and optionee. And likewise, in the option agreement, you want to make sure you are identifying the parties as optionor and optionee, not as lessor or lessee, because again, we're really trying to establish the two separate obligations. Something else, I mentioned that I don't recommend including the option agreement as an exhibit to the lease. I have seen that in the past before, but just the recent court decisions, that makes me a little nervous, and I recommend not doing that. Also, the option fee should probably be something more than a nominal fee. You're not going to charge $50. It needs to be something reasonable. I don't have a way to calculate exactly what's reasonable, but depending on the purchase price, you know, it could be several $1,000s. So that's something you want to discuss with your attorney and make sure you're giving that some thought. If it looks like a sweetheart deal, that can give you problems.
We have a question real quick while you're on those option terms. What do you typically see for an option term? Is it 1 to 3 years? Like how long do they have to exercise the option?
I mean, really, I don't see many sellers offering an option term in excess of a year. That's a pretty long time to hold your property off the market. So, you know, but you could do it longer. But if I were a seller, you know, I'm going to collect a larger option fee.
Yeah. And I really, you know, to your point, in our market, you know, I would say certainly the average price point has crept up, but I really haven't seen an option fee less than $5,000.
Me neither.
I really don't like, even if it's a $200,000 property, I still wouldn't feel comfortable at $1,000 or $2,000. I want to see like a chunk there. You know, just to make sure that that's going to be enforceable, because here's the thing. Everybody, when we start talking about this, wants to start complaining, especially once you've broken the news that it's not going to apply to the purchase price. And then everybody's like, well, I don't want to pay for this. But the problem is, if you're the tenant and you want that option to be valid, if that's not proper consideration and the seller says, hey, I want to go sell to somebody else now, because it's like, if this was a year ago and now look how the market is so much different from, you know, this April to last April. If you're the buyer trying to hold that seller to the deal, then if your valid option fee isn't valid, then you don't have a deal. So there's no way to have it both ways. We have another question: is the option fee refundable to the tenant if the option does not move forward?
The only way that the option fee should be refundable, and that's a very good question. It absolutely should be non-refundable unless the seller somehow defaults on their obligations. If they just refuse to sell. And the example that Joanne was just offering, where, oh my gosh, the market's spiked 40%. I don't want to sell to this buyer anymore. I can get way more than that. I'm just going to default and he can come chase me in court. In that instance, yes, the option fee should be refundable, but under no other circumstances should it be refundable.
Yeah,
that was a good question.
Otherwise, it's not an option fee.
And there's another good question that I was actually going to be getting to. Do all options have a set purchase price? That is something that I definitely recommend baked into your option agreement. Needs to be more than just the baseline terms of the purchase. I've seen options where you have the purchase price specified the deposit and the closing date, and that's it. There's a lot more, as everyone knows, that goes into a residential purchase agreement. So what I recommend and what I require typically is that we have a draft contract that is agreed upon, and it serves as an exhibit to the option agreement, so that we know when buyer exercises their option, the parties have to sign this agreement with these terms. There's no squabbling or discussion after the fact. I also recommend, especially if you're a seller, that the inspection period is waived in the contract, because the buyer's going to have the option term to do their inspections. What you don't want to happen is you go under contract and now the buyer does their inspection and they terminate under the inspection provision. So I definitely recommend, yes, that as many of the agreement terms are specified in advance, and preferably that you have that attached to the option agreement so that there's no squabbles at the time the option is exercised, for sure.
That option fee, when that's paid, is that paid directly to the seller? Is that paid to the closing agent? How do you see that typically being addressed?
So that can go either way. Some sellers want it in their hand, and they say, you need to trust me. I'm collecting this option fee. It's non-refundable. If I don't perform, you can sue me and get it back. If I represent the buyer, absolutely not. If I represent the buyer, I'm, as their attorney, I'm going to hold that in escrow, so that we can protect that option fee in the event the seller doesn't perform. So that's a really good question too. Let me see. I mentioned that there's a certain clause that you want to include in the lease, but there also needs to be a very similar clause that you include in the option agreement that acknowledges the fact that the buyer is not gaining any kind of equitable interest. So I have one more little clause that I wanted to share with everybody.
Just a little one.
Just a little one. And
almost
of course,
as tall
it's
as me,
bolded and underlined.
Ooh, the whole thing bold and underlined.
So this is a very similar clause to what we were including in the lease. But again, this is something that needs to be in the option agreement as well. It makes it that much more difficult for the buyer to claim that they were unaware that they weren't getting any kind of equitable interest. And it's also going to be harder for, again, the judge to ignore. So this is just an example. Don't run with it without talking to your attorney first. But just wanted to share that as well. Any other thoughts on the lease option before we move on to the lease purchase?
I don't have any other questions. I think we're good there.
All right, perfect. So with the lease purchase, again, this is a residential lease agreement that is signed at the same time as a purchase agreement is signed. And so the parties are really bound by these agreement terms. There's no option, there's no backing out. You want to make sure that you have a reasonable deposit, not only for the lease, but also a reasonable deposit for the purchase agreement. And this is because I think everybody can agree, the more time you spend in a home, the more you start to notice things that you like and you don't like. If you don't have a reasonable deposit under the purchase agreement and you let someone come and preoccupy in the property, even if it's only for a couple of months, you run the risk that they sort of fall out of love with the property and then try to back out. And if you don't have something tethering them to their purchase obligations under the purchase agreement, that's kind of a big risk that you're running. And I have seen parties sort of fall into that where they're like, well, I'd rather have the lease deposit so that if they break some stuff or damage some stuff, I have something to apply against that. And they don't want to pay a lease deposit and a hefty purchase deposit. So you have to kind of weigh the risks there. But I definitely recommend a good deposit under both.
The other thing to consider, to your point there, sometimes it's not even the house, it's the neighbors. And neighbors will chat and they'll be like, oh my gosh, this guy's had all sorts of air conditioning problems. Didn't he tell you? And it's just, and you can't run from that everywhere, but that is something to be mindful of, particularly if you know that maybe there's some acrimony in the neighborhood, or, there's some reason that somebody might want to sabotage a sale for this guy, or, if you're the agent putting this together and that there's some issues, that might be another thing to just put everybody on point for, that like maybe that's not the best idea, because it gives them not only a chance, like you said, to try before you buy on the house, but also like the neighbors are loud, or the dog is barking, or things that otherwise are not home inspection related, and then now you're stuck starting over with something like this.
Right. Right, exactly. Again, the rental, you want to make sure that you're charging a fair rental. You don't want this to be a sweetheart deal. And you also, again, going back to the common expenses that the landlord assumes, something I've seen parties do in a lease purchase scenario is they basically negotiate in the purchase agreement that the expenditures of the landlord under the lease agreement under certain circumstances will act as a credit and automatically increase the purchase price under the purchase agreement. And a judge is going to see right through that. That is absolutely going to vest an equitable interest in the buyer. So you need to be careful about that. Anytime you try to get creative with these terms,
someone else already thought of it.
Someone else has already thought of it and has already been burned in court. So I don't recommend
and
that.
They were in Miami.
And they were in Miami. Or they fell into my lap and came to me after the fact and were like, dang it. Because for some reason, I see some of these horror stories and I feel bad for the parties, but they learn from it, and you're now learning from their mistakes.
Yeah.
Also, again, in this same context, you want to make sure the purchase agreement lists the parties as buyer and seller. The lease lists them as landlord tenant. We don't want to interchange those kinds of terms that can really get you into problems. Also, you want to make sure that in the deposit, that it is a reasonable amount of the deposit. I mentioned before that we want to make sure there's deposit under each agreement, but it also needs to be something that's reasonable. And also, again, the proration of HOA fees. I see that a lot, taxes and HOA fees. People try to provide under the purchase agreement that you're going to prorate that back to the date that the lease started. That, again, is going to establish an equitable interest of the buyer in the property. So you really, really want to make sure you're careful about not doing that. And lastly,
and the thing is those are typically not a ton of money. So you're really jeopardizing a transaction over a few bucks. It really is not worth it.
Right. And a lot of times people do this because it makes logical sense. If the buyer's willing to cover that expense, why not allocate it to them?
Right.
But in the particular circumstances of a lease and a purchase agreement, or a lease and an option agreement, things like that can really put a seller in a difficult position if they need to get rid of the tenant because they aren't performing or they've defaulted. And again, now they're looking at a judicial foreclosure versus a swift eviction. Yeah. And again, that goes back to default provisions. A lot of times these agreements have cross default provisions, and the way that these look are going to depend on which party I represent. So you need to make sure that your attorney is taking a look at that and assisting you in crafting that properly, because what works in one agreement may not work in another agreement in terms of these cross default provisions. And really, it goes for all of the provisions in the lease option or in a lease purchase. You really want to make sure you're careful and looking at the provisions with your attorney based on these particular facts and circumstances, because there are a bunch of wiggly factors that can make a difference. So that's, I don't have any scary clauses, additional scary clauses to share.
And underlined here.
Yeah. But those are my main, main points I wanted to share based on what I've seen coming down in court decisions and what I've seen happening across the conference table for me, and speaking with clients that come after the fact and they have decent agreements in place that maybe would have been upheld 5 or 10 years ago. Right. But for whatever reason, the climate is changing a little bit, and you have to be that much more careful with your terms now.
Definitely. And the other thing I want to kind of talk about is a practical standpoint, because of course you're always spectacular at the technical. But from a practical standpoint, if you are a realtor and you are putting one of these deals together, you need to be very on top of this to make sure that you have your compensation structure in place before you do all this work, and then you don't get paid. So, because oftentimes what happens is the realtor has done the work, put it together, and then calls us and says, hey, I've got this, can you do the paperwork? And then the like afterthought is, now how do I get paid? You really, especially if you're doing a lease option where the person may or may not actually purchase, you need to make sure that you've got a compensation agreement in place so that you're compensated on the lease at that point in time. You have to be careful, another benefit, I guess, to having the more terms and really, even if we can get that contract in place as to what they're going to sign, have that FAR bar ready to go as an exhibit to the lease agreement that says this is exactly what they're going to sign that day that they exercise the option, and you're listed as the broker, either the listing agent or the selling agent there. That's also going to build in protection for you when they exercise that option, that this doesn't go away. This is another reason why we don't want to see those option periods get too longish. If it's 3 years later and you haven't done anything and you're not talking to these people, like, you're really no longer the procuring cause. And if something goes sideways, you can lose your claim to your compensation for that transaction. So we want to see these things be not super tight in time frame. You wouldn't do this for a month. We'd be looking at a pre-closing occupancy agreement if that was the case, to a purchase contract. But sometimes, people call me about a long pre-closing occupancy agreement, and it's like, well, pre-closing occupancy is really not a year.
Right.
We really need to start looking at, a lease purchase or something like that. So we need to make sure that you've got, the proper agreement in place so that you get compensated under the lease and that you are also compensated under the purchase. So just something practical to be mindful of, because what you don't want to do is put it together and then try to be shoving agreements under these people's noses like, hey, don't forget about me, because they've, as our friend Mike Francois says, the value of the services immediately declines the moment it's been performed. So
right.
They thought you were brilliant when you came up with the idea, and not so much when someone has to pay for it. They do it to us too. Mm-hmm. Especially to us. But so that's just something else, kind of from a practical standpoint, to consider, to be mindful of, and really, before you start throwing that out there, to make sure that you've got some idea that the person might need this. And it usually comes up in a conversation with the buyer who maybe potentially could become a tenant. People have a tendency to be in some kind of life transition. Maybe they're not certain about a transfer or relocation or a school district, and they're saying, I think I want to be down here, so I'd rather not move twice, but I'm maybe not ready to commit just this second. We saw them also, of course, when people were coming out of the downturn and short sales and people didn't have credit in place. That less is the motivator now, and it's really more motivated by uncertainty about location. Maybe my kids
right.
get into IMG, or maybe, whatever the geography is deciding. So those are just some things to consider. As always, we are happy to field your questions. So we've had great questions today. You're welcome to email us follow-up questions. You are also welcome to email us further topics that you'd like to hear about. Next week, we'll be on with John Cipher, who is going to be talking about whether or not you should be growing your business. Is it the timing right, and what steps you need to have in place before you undertake to make it bigger, before you make it better. So thank you so much, Jackie, for your expertise and your bolds and underlines. I'm sure Wade loves those. Have a great week, guys. We'll see you next week.
Bye-bye.
Bye.